problems with that? Summary matters. Just come forward, ma'am, just proceed. Well, please be seated, Ms. Jordan. I think I'm prepared to proceed. I think that there's, I appreciate the Crown's position, but I think under the circumstances, I'm going to not allow the Crown the opportunity to adjourn the matter and call Ms. Roger forward for cross-examination purposes on her affidavit. So we'll just proceed with the decision this morning. All right, and thank you, Ms. Jordan, for being here on behalf of Ms. Roger. Ms. Roger was found guilty after trial of 3 offences under the Halifax Regional Municipality Bylaw A300 as follows. First, that she owned a dog which ran at large, contrary to Section 7.3. Secondly, that she owned a dog which attacked an animal, contrary to Section 8.1. And thirdly, that she failed to comply with a notice to muzzle her dog, contrary to Section 8.4. As this matter has taken an inordinate amount of court time to date, the court sought written submissions from the parties on sentencing. Because Ms. Roger is a self-represented person, the Crown obliged the court and filed its submissions first, allowing Ms. Roger to review the Crown's position before having to put forward her own, as would normally be the case when defence evidence is presented, as was the case here. And I would note on the record here that Ms. Roger has chosen not to appear. I do not know the reasons for that, but it's a summary matter and has, as agent, Ms. Susan Jordan here on her behalf. These charges arose following the seizure of Ms. Roger's 9-year-old Labrador mixed breed dog named Brindy on September 27, 2010. As a result of a complaint that Brindy had attacked a dog called Lucy, belonging to Mr. and Mrs. Sims, who reside in the same community of East Chesapeake as Ms. Roger. This matter represents the 3rd occurrence of Brindy attacking another dog. Brindy was also involved in 4 reported incidents of running at large. A brief history of these past incidences involving Brindy is necessary in order to provide a backdrop to the court's sentencing decision in these matters. On July 24, 2008, an animal control officer executed a warrant to seize Brindy and to have her destroyed under Section 8.2d of the then Animal Bylaw, based on 3 incidences of Brindy attacking other dogs without provocation. Following an application by Ms. Roger to the Supreme Court of Nova Scotia, this section was struck down as being ultra-virus as it denied procedural fairness and prevented Ms. Roger an opportunity to influence the animal control officer's decision to destroy her dog. Within the context of this decision, dated January 16, 2009, His Lordship Justice Duncan Beveridge outlined the record with respect to the dog in question, Brindy, to which I shall refer. According to His Lordship, this record demonstrated that there were 4 incidents between August 21st, 2007 and July 20th, 2008, 3 of which involved Brindy attacking dogs that were walking by the defendant's property in East Chesapeake. The first incident on August 21st, 2007 involved Brindy breaking her chain and attacking a woman's dog while she was walking her dog on a leash past Ms. Roger's property. This dog received puncture wounds around the neck and on her legs. With respect to this incident, Ms. Roger received a notice under then HRN Bylaw number D100, a formal warning for owning a dog that without provocation attacked another animal. Brindy was also not registered and received a notice requiring Ms. Roger to do so, which she did. In the meantime, on September 13, 2007, a complaint was received by HRM of a dog running at large. The dog turned out to be Brindy, and Ms. Roger explained to the animal control officer at that time that Brindy had gotten free from her chain. She was issued a D100 formal warning permit for permitting the dog to run at large. On April 21, 2008, another complaint was received from Ms. Villieu, who had been walking her dog on a leash in the area of Ms. Roger's home when Brindy attacked her dog, knocking this particular lady down in the process. Her dog was injured, and Ms. Roger paid the vet bill of $363.62. On this occasion, Ms. Roger acknowledged that she was in her yard and Brindy ran to the street edge, and despite ordering Brindy to stay, she continued. Ms. Roger insisted that her dog Brindy did not leave the property. Ms. Raja injured her finger in this incident, requiring medical attention when attempting to intervene. She did acknowledge that Brindy had attacked another dog in the past a few times, but that there were no major injuries. As the vet bill had been paid, Ms. Beaulieu did not want Ms. Raja to be fined as well, and so the Animal Services Officer issued a muzzle order instead of a fine. According to the Animal Services Officer, this order would deem the dog fierce and dangerous, and the dog could be seized if it left the residence without a muzzle on, attack or not. This was done on May 2, 2008, and served on Ms. Raja. On the morning of July 20, 2008, HRM Animal Services received a further complaint from two individuals that Brindy had attacked two dogs while being walked on a leash past Ms. Raja's property by their owner's son. Brindy was not on his property, was not leashed nor muzzled. Brindy bit the larger of the two dogs, which was a guide dog. This dog did not suffer any significant injuries. In what Justice Duncan described as a cryptic explanation by Ms. Raja as to what had happened on that day, while she did not deny that Brindy had attacked the other dog, all she could say was that she was preparing Brindy to go out, and while putting her muzzle on, Brindy got away and out the back door. After Section 8.2d of the Animal Bylaw was struck down, Ms. Raja was charged with 3 counts of violating the Animal Bylaw. On February 23, 2010, Ms. Raja was found guilty of the same 3 charges, for which she is now found guilty in the within matter. Brindy was under a muzzle order at the time of the previous offences, and Her Honour Judge Murphy of this court found that this order had not been adequately complied with. And while the Crown at that time sought to have Brindy destroyed pursuant to Section 177 of the Municipal Government Act, which was the same wording as the current Section 195 of the HRM Charter, Her Honour Judge Murphy did not find this would be the appropriate sentence under the circumstances, and released Brindy back into Ms. Raja's care under the most strict of conditions, including obedience and aggression control training, to restrain Brindy at all times, either indoors or, when outdoors, muzzled at all times, and inside an escape-proof enclosure that does not allow the dog to jump, climb, or dig its way out. When Brindy was outside the residence and not in the escape-proof enclosure, Brindy was ordered to be muzzled, securely leashed, and under the control of a person not under the age of 18 years of age, who had experience and a proven ability to control Brindy. Ms. Raja completed the necessary training with dog trainer Ms. Susan Jordan, and Brindy was released into her care on July 9, 2010. The next attack occurred on September 14, 2010, some 2 months and 5 days later, which facts are set out in my decision following the trial in this matter. Under Section 18.1 of the Animal Bylaw, the minimum fine for a contravention of this bylaw is $200, and the maximum fine is set at $5,000. Therefore, as Ms. Raja has been found guilty after trial of 3 contraventions, the total minimum fine which the court must impose is $600. As the Crown is seeking the additional penalty of an order for the dog to be euthanized, the Crown submits that should the court so order, that the minimum fine of $600 is appropriate. Although this might be considered on the low end, as this is Ms. Raja's second set of offences occurring just 2 months after the first. The destruction of the dog is a very severe penalty, and no further fine would be required to ensure proper general and specific deterrence according to the Crown. Ms. Raja submits that on 4 occasions since HRM first seized Brindy in July 2008, that Brindy has been assessed by qualified persons with experience in evaluating dogs, and all results have been positive ones. A report by Ms. Susan Jordan, an expert in dog training, clearly indicates that Brindy is trainable. As well, at trial, Ms. Jordan testified that Brindy was trainable and indeed had received some training, as had Ms. Raja when the within events occurred. Brindy's problem area is that she has territorial aggression, dog to dog. The expert was of the opinion that with more work, Brindy could get over this issue. Obviously, Brindy was not at this point when she attacked and bit Lucy. Ms. Raja had called the expert immediately following this event. Ms. Jordan testified at trial that Ms. Raja told her that Brindy had gotten loose, that she felt that Brindy had moved out of the car, and the other dog moved towards Brindy, and that the other dog was off-leash. Brindy attacked the other dog on property, meaning Ms. Raja's property. This was not a true version of the facts. My decision following trial makes it clear that Brindy had jumped through an open window in Ms. Raja's car and had attacked Lucy in the middle of the road. Lucy did not move toward Brindy, and Lucy was most definitely on a leash. This deception by Ms. Raja in her description of events to Ms. Jordan lessens somewhat the impact of Ms. Jordan's opinion. Nevertheless, there is no evidence to the contrary that Brindy is not beyond redemption. Sadly, I find that Ms. Raja is, as far as her ability to control Brindy is concerned. and as a result has put Brindy's life in jeopardy, and as well has placed the safety of the public in jeopardy. I have read the affidavits of Ms. Jen Richardson and Ms. Elizabeth Lindsay, who both are pet owners, and state that Ms. Roger has kept Brindy leashed and muzzled as required in their presence. They both view her as a responsible pet owner, and additional affidavits just filed, I think they were just filed late yesterday, which I have had a chance to review, also support this opinion. Respectfully, I disagree. Indeed, I would describe Ms. Roger inexplicably under all the circumstances as an irresponsible pet owner who has known since she acquired Brindy in 2007 that Brindy has aggression issues. As a result, Brindy has, being unprovoked, attacked and bitten other dogs in the community who were being properly walked and leashed by their owners, and Ms. Roger was unable to control Brindy or ensure that Brindy was under control. Ms. Roger stresses that Brindy has never bitten a human being, and that the injuries suffered by those dogs she has attacked are not serious. While she expresses remorse for both her lack of due diligence and the actions of her dog, she is basically unrepentant and leaves the court with the impression that she views Brindy's unprovoked attacks as nothing to make a fuss about, and in the process causes her undue hardship. While she does love Brindy and considers her as her family, she does not seem to appreciate that the other dogs that Brindy has bitten, those owners also feel that their animals are family pets, I would assume, or family loved ones, I would assume. In this instant matter, Brindy, in my opinion, based on the evidence, in biting Lucy, caused a wound to Lucy that penetrated through her skin and fatty tissue. This was a deep bite and caused Lucy a lot of pain, a trip to the vet for antibiotics, and as a result, Lucy has become a less confident pet. But for Mr. and Mrs. Sims kicking at Brindy in order to get her to release her hold on Lucy that night, Lucy could well have been much more seriously injured. Nevertheless, the community has the right to be able to take an evening stroll with their family pets without having to fear that a dog will suddenly jump out of a car window and attack their dog. As Mr. Sims described in his testimony, it was a terrifying experience. The attack on Lucy by Brindy was treacherous enough, but what makes it all the more aggravating, in my opinion, is the fact that, because of a prior event involving Brindy being unprovoked yet attacking another innocent dog, Ms. Roger was on very strict court conditions, which included that she had to keep Brindy secure, leashed and muzzled, and or in an escape-proof enclosure when out of doors. Ms. Roger testified at trial that she had just picked up a new car that day and had difficulty getting the windows to operate, thus Brindy was able to jump out. Given that explanation and admitting her knowledge that Brindy was in her car on the roadway with the window open, unmuzzled and unleashed, surely under these circumstances and being under court order to do so in any event, Ms. Roger should have taken meticulous care to ensure that Brindy was muzzled and leashed. She did not take such care. There was no due diligence on the part of Ms. Roger whatsoever. In her honor, Judge Murphy's decision of April 30th, 2012, Judge Murphy states the following, quote, "The reality is that I cannot concede that there is any dog owner who can be more cognizant of what the cost will likely be or likely outcome will be for Brindy if there is a further incident of dog aggression that results in charges than Ms. Roger must be. I do not think that I am overstating the likely outcome to suggest that Brindy likely would be destroyed if there was a further incident. A court could very likely conclude that Ms. Roger is not able to control the behavior of her pet to the standard that she ought, and a court could, and I suspect would, conclude that all reasonable chances have been given to both dog owner and dog, and they have been unsuccessful. At that stage, a court could find itself with no other choice than to order to have Brindy put down. So, Ms. Roger, it is up to you to ensure that Brindy and other dogs are not put at risk by Brindy's aggressive behavior." End of quote. And here we are today. While I acknowledge that Ms. Roger loves her dog Brindy, Brindy has spent the greater part of her life under the care of HRM than under the care of Ms. Roger. The responsibility for this sad fact lies squarely at the feet of Ms. Roger. But for her complacency in ensuring that Brindy could not act out her territorial aggression on other innocent dogs, after having been given more than adequate opportunity to do so, I am satisfied that Brindy cannot safely be returned to Ms. Roger. Therefore, I order that ownership of the dog Brindy shall be forfeited to HRM immediately, and from henceforth HRM shall have the sole responsibility to make all decisions concerning Brindy's care and custody. Furthermore, I direct HRM to provide Brindy with the same opportunities given to other animals that come into its care, In that, I mean that Brindy be provided with the usual assessment as to her ability to be adopted or fostered to a person or persons who can provide her with all the due care, but who can also keep her under the controls as set out in Judge Murphy's judgment. In Judge Murphy's judgment of April the 30th, 2010. Should HRM not find such a foster or adoptive home in the usual manner, or as a result of ill health as established by a veterinarian as retained by HRM, I also order that HRM has the right to euthanize Brindy in the most humane way possible, but in any circumstances not prior to August 1st, 2012. I further order that Ms. Roger be fined $200 on each count for a total fine of $600 to be paid on or before December 31st, 2012. Thank you very much. Okay. The court will take a short recess.